Emerson Sykes, a staff attorney with the ACLU's Speech, Privacy, and Technology Project, where he focuses on First Amendment free speech protections. Prior to joining the ACLU, he was a legal advisor for Africa at the International Center for Nonprofit Law. So we're going to hear from both Nico and Emerson, and then we're going to open it up to questions, including questions from our audience. Thank you so much.
Thank you so much, Sushma. So I'd like to just begin today by just grounding us a little bit. First, why do I personally, as a lawyer, but more so as a person of color, as a Mexican American, care about critical race theory? And second, I'm going to address what, or at least partially, what CRT is. And then third, and perhaps provocatively, I'm going to argue why CRT is dangerous, or at least dangerous to those who are trying to silence the discussion of CRT and related concepts in our academic institutions. So I should state from the beginning that I'm a graduate from a proud graduate from the UCLA School of Law Critical Race Studies program. It's the only such program in the nation, and I think it provided me an excellent training both for law and for the mode of inquiry that is critical race theory. But I want to talk to you a little bit about what brought me to the program. So going to public high school in San Jose, California's Eastside Union High School District, I began to see students of color like myself dropping out or being pushed out from the school. Others, like myself, found themselves constantly tracked into programs that wouldn't give us a meaningful opportunity to go to college. And as many of these issues came to a head in my school, there was a meeting with Black and brown students and some concerned teachers. And there was definitely a feeling of anger and frustration, including on my own part. And in trying to make sense of the situation, I remember saying something to the effect that I didn't think that the school cared about us very much. I might have used slightly different words at that time, and maybe ones that I don't want permanently recorded on Zoom. But I definitely didn't have a good vocabulary to describe the dynamics that I saw happening, other than the result to the communities that I cared about. Fast forward a few years, and I began working at an organization called College Track that was looking to ameliorate some of these problems, to provide a meaningful path to Black and brown students to be able to get everything they needed to go to college. But yet many structural barriers still stood in their way, including, and by no means limited to, the fact that many undocumented students and many of the particularly Latino students were undocumented, couldn't afford to go to school. They were being forced to pay the equivalent of out-of-state tuition. And this is prior to me going to law school. And once again, I didn't have a vocabulary or an understanding of how to address these problems. So in my decision to go to law school, I found that there was one law school that taught critical race theory as a concentration within it. So I decided to go there. And I think that it now provides me a much better vocabulary and framework for how to understand these issues. And I've found it useful in addressing these and other issues in the course of my legal career. So I want to turn a little bit to what CRT is and give us a little bit of background on critical race theory. There's no way we can cover the entirety of the subject, but I'm going to try to do some of the broad outlines here for purposes of grounding us. So critical race theory, as I mentioned, is a scholarly legal inquiry that asks how and why gaping racial inequalities remain durable and pervasive in our society. And this continuation of racial inequality is despite the fact that over 70 years ago, there has been an official repudiation of white supremacy within the law in Brown v. Board of Education, which fundamentally changed our equal protection doctrine and the constitutional understanding of what that equal protection right is. And critical race theory really emerged in the legal academy as a way, despite this move to formal equality that we see in Brown v. Board of Education, of the way in which society has structured racial inequality into everyday institutions, practices, and policies. Critical race theory, like all modes of scholarly inquiry, isn't a set of dogmas. There aren't some core assumptions that structure, but there are some core assumptions that structure the mode of inquiry. The first is that there's no natural explanation for contemporary patterns of racial inequality. That is, there isn't necessary inferiority, biological or cultural, of racial minority groups. Or, critically, that existing conceptions of legal rights are the only way these rights can or should be interpreted. That is, they don't constitute a neutral principle of legal rights. So two assumptions about the cause of racial, that really structure the cause of racial inequality. A second core principle is that race is a social construction. That is, it's made up of these various legal and social practices, but that it nevertheless has real social effects that limit and delimit the opportunities that racial minorities have. A third major assumption is that racism is not just the moral failing of a few bad actors, that rather, in order to grasp how racism functions, we have to understand that there are systems in place that function to further inequality. And so one way to understand how this inquiry works is that CRT really is a look into the wider ways that racism works. And it helps us understand why seemingly race-neutral or colorblind conceptions of the law actually serve to underwrite these systemic inequalities. And so I'd like to take just a moment to talk a little bit about how it does this. So I describe some of these terms. So modern equal protection doctrine that I discussed is structured around what has been described as an anti-discrimination principle rather than what could be described as an anti-subordination principle. So the anti-subordination principle of equal protection would focus equal protection guarantees on ensuring the state does not engage in practices that would reinforce inferior social status of historically oppressed groups, regardless of whether or not subordination was the actual intent of the state actors. In contrast, the anti-discrimination principle, which is often referred to both affirmatively and derisively as colorblindness, views the equal protection norm as one that posits racial categories do not matter and should not be considered when making decisions such as hiring and school admissions, and that social categories should be dismantled and disregarded, and that everyone should be treated as an individual. In many ways, we can understand this latter anti-discrimination principle as a repudiation of an alternative anti-subordination conception of equal protection. So this notion, this colorblind notion, has a central tenet that race in governmental decision-making is presumptively illegitimate. And so here, between these two ideas, we have two conceptions of what might be the equal protection principle. And we can use various tools of legal inquiry to try to understand which was the original intent of the framers and which is not. And that might be one mode of going about doing it, this kind of textual analysis. We can look back to historical practices, and we can engage in this effort to understand which of these we should incorporate. We can ask which better serves to address current inequalities, and we can have debates and discussions about these things. This is what critical race theory intends to do. It attempts to argue why an anti-subordination principle that looks at, for example, the way in which school funding is allocated or the way in which political districts are drawn, and says, even if they didn't take into account race on their face, nevertheless, are they functioning to continue the subordination of people of color? If so, then the law needs to do something to redress it. This is an alternate conception of what the equal protection doctrine could encompass. This is just one way in which critical race theory, as a legal construction developed within legal institutions, attempts to grapple with these problems, debate them, explain them, and posit potential solutions to them. So rather than being rather than being a system of thought which seeks to demonize individuals for their race, as many detractors of critical race theory attempt to claim that it is, critical race theory actually goes in an opposite direction. That is, it attempts to look at structural institutions to understand racial dynamics. And in doing so, critical race theory is essentially a democratic project, in the sense that it is trying to further the goal of equality in the society by naming existing inequalities, as well as providing pathways to allow us to achieve it by identifying existing forms of subordination. So I said that I wanted to explain a little bit about why critical race theory, as I've described it, is nevertheless dangerous. I don't think that it's a coincidence that these attacks on critical race theory are coming at a time when there is a growing urgency and popular support for greater investigations of racial inequality, especially in the wake of the killings of George Floyd, Breonna Taylor, and Ahmaud Arbery. And while the detractors of CRT are trying to stigmatize it as needlessly divisive and racially inflammatory, and are stoked in moral panic over public educational efforts to combat racism, whether they be some mild incorporation of CRT into the K-12 doctrine, or other discussions of systemic racism or racial inequality within schools. The effect of doing so, the effect of shutting off these discussions, and I believe it is the intended effect, would be to shut down public discussion in our educational institutions of systemic racism. It also has the effect, really, of shifting the focus from what are some bad actors in our society and some real dynamics which are continuing racial subordination in our society. Whether they be those who are opposing our attempts to grapple with police brutality, or whether it's to take away focus from the backers of the Capitol insurrection, or whether it's to turn our gaze away from the fact that there are increasing voter restriction laws being passed in multiple states throughout the country. This focus on CRT and attempting to claim that it's a boogeyman is really taking our focus away from these other dynamics, which are going to have lasting impacts on our ability for marginalized communities to have a voice and to have the matters which affect them be heard today. So that's one thing. So there's maybe the real politic of what this focus on CRT is. But there's also, I think, a real core reason why CRT may be viewed as dangerous by those who want to maintain existing forms of subordination. That is, as I've mentioned, CRT really tries to expose the past and present existence, as well as current causes of racial inequalities. That is, it tries to highlight the fact that they're existing, they're the products of structures and choices in this society. And in doing so, it's really arguing that these choices didn't have to be that way, and that the current legal and social arrangements don't have to be this way. For going back to my example of the anti-discrimination or the anti-subordination principle, this was a legal choice that was made about how to view the equal protection doctrine. And by continuing to highlight the socially contingent nature of these relationships, it destabilizes the hegemony of existing legal norms. And in doing so, it leaves open the possibility for other contested notions of rights claims and social arrangements. In doing so, I think it really is furthering this democratic project. I think that it is trying to push forward our ability as lawyers, as educators, as members of marginalized and subordinated groups to find ways to talk about what's affecting us and to make claims that it doesn't have to be that way. And so with that, I'd like to turn it over to my colleague Emerson, who's going to talk to us a little bit more about what it looks like right now in the current legal landscape.
Thanks, Nico. It's a great pleasure to be with you today. I think that was important to start with Nico talking about what CRT is, because in many ways, I'm here to talk about mostly what CRT is not, and the ways in which we're litigating against these so-called bans on CRT, which I would argue in many ways have nothing to do with the academic discipline and the mode of inquiry that Nico just described. So my name is Emerson Sykes. I'm a senior staff attorney at the American Civil Liberties Union. I work in the Speech, Privacy, and Technology Project, as Sushma mentioned. But just to orient you a little bit with the ACLU, we have affiliates in all 50 states, and then we have a national office. And within our national office, we have a communications team. We have a national political advocacy department where we have organizers as well as legislative advocates. And then we have our legal department where we focus on litigation. So I just want to orient us because I want to say that it's very clear, maybe for everyone, but it's worth saying anyway, that litigation is one very small piece of the broader fight for sort of the national reckoning that we're seeing with our history, with how race and identity affect our everyday lives. So I'm going to talk about my role as a litigator, addressing a very particular way that we think that we can push back against this sort of fad that we've seen across the nation. I don't mean to minimize it by calling it a fad. It certainly is a political buzzword. CRT has become a political buzzword that's having a lot of success and traction. But of course, it's not just about some recent political fad. This is a part of our sort of national story and our national reckoning with how race and gender have played into our histories and into our culture. So I want to also say that, our communications team has been doing a lot of work on this. That's why we really don't use the term critical race theory when we talk about what's going on currently. We talk about bans on inclusive education because they sort of are using CRT as an umbrella term to cover everything from diversity trainings at work to including women and non-white folks on reading lists. So trying to sort of reclaim CRT for exactly what Nico was talking about and talk about bans on inclusive education for all of these other things that are being sort of painted with that same brush. And what we're seeing, as I said, is a lot of success on the other side. We've seen 27 states at my last count have introduced laws trying to limit inclusive education. 8 states, I think, at my last count, have passed such a law. And then there are countless other policies, state boards of education, districts, school level decisions that have been impacted by this sort of national trend. And of course, the real impact has been on teachers who don't know what they cannot say. And this has a chilling effect, which I think undoubtedly is the point. Beyond whatever these laws say or don't say or how they're enforced or not enforced, the point is to try to discourage teachers from discussing racism and sexism and other forms of discrimination, other forms of oppression that we've seen in our history and our culture in the classroom. So, as I said, these laws have been introduced in lots and lots of places. A lot of them cut verbatim from an executive order that was passed by President Trump. Thankfully, it was subsequently enjoined by a federal court, and then President Biden withdrew it. So it's no longer in effect, but it has lived on in these other state measures, and as I said, at the local level as well. And I just want to spend a couple of minutes, and then I'll stop talking. I just wanted to spend a couple of minutes talking about a particular case that we're working on right now. I'm super proud to be on a team at the ACLU National, both the Speech Privacy and Technology Project, where I work on First Amendment rights. We're teaming up with our Racial Justice Project. The ACLU National has lots and lots of different projects: racial justice, women's rights, immigrants' rights, all those different things. But the speech team and the racial justice team are combining efforts with the ACLU of Oklahoma, the Lawyers Committee for Civil Rights Under the Law, and Pro Bono Counsel from Schulte, Roth, and Zabel. And we filed a case last week. Is it last week or 2 weeks ago now? Last week we filed the case. It's been a long week. And challenging the Oklahoma HB 1775. So if you want to just indulge me for 1 second, I hope you can see my slideshow. What I have up right now is a picture of the Oklahoma University Black Emergency Response Team. And I could not be more proud than to be their attorney. They have stood up to challenge this law because in many ways they are the target of this law. It's a national trend. These laws have a lot of things in common, but every single policy, every single law has its own local history and local story. And in Oklahoma, in the anniversary, in the centennial of the Tulsa Race Massacre, which incidentally 3/4 of Oklahomans were never taught about the Tulsa Race Massacre in their public education. But in this unique state, at this unique time, the Black Emergency Response Team, founded in 2019, stood up, had protests in response to some racist incidents on campus. They created a list of demands. Through their own power and their protest and their advocacy, they achieved many of the pieces of their demands, including the institution of mandatory coursework for all incoming freshmen about how to live and thrive in a heterogeneous community. The law in Oklahoma specifically targets, let me show you in the next slide, any orientation or requirement that presents any form of race or sex stereotyping or bias is prohibited in Oklahoma public colleges and universities. So this might look familiar based on the story I just told you, right? So this law specifically prohibits the presentation of any form of race or sex stereotypes or bias. But note that it doesn't say the perpetuation of stereotypes or bias. It says you can't even present stereotypes or bias in any orientation. I think that was included specifically to target the Black Emergency Response Team, or requirement, which I think has to be read to include course requirements, required courses like the US History Survey that is required of all Oklahoma University students, or perhaps requirements within a major. If you're a sociology major, you can't be required. There can be no required course or requirement of any kind that, quote, presents any form of race or sex stereotyping or bias, even, presumably, if you're presenting those ideas in order to counteract them. The law affects higher education. Some of the laws around the country and policies affect higher education, some of them don't. The First Amendment has special protections in the higher education context, so it's notable that in Oklahoma it does cover higher education. But it also has verbatim the 8 prohibited concepts for primary and secondary schools from the Trump executive order, and that we've seen in so many of these laws. Among the sort of lowlights of this list of 8 concepts, most of them are sort of framed around, like the previous quote, sort of don't say anything racist. But the pretext is don't talk about racism. And of course, we understand that that is not the way to address and overcome racism. Of course, we have to explore it, we have to study it, we have to talk about it, and only then can we move past it. So, but not only are they misguided, but they're also indecipherable. So one of the banned concepts is that you're not allowed to make part of a course, right? So no teacher in a primary or secondary school can make part of a course the concept that, quote, members of one race or sex cannot and should not attempt to treat others without respect to race or sex. Now, that might have almost made sense when I started reading it, but I assure you that I did not make sense when I finished, because this is literally incomprehensible. The sentence doesn't make sense. So we've brought 4 claims against this law. One is a vagueness claim, a due process vagueness claim, because of provisions like this, which literally you don't know what they mean. And if you don't know what they mean, how can you be held accountable for violating the law? This law carries penalties, including the loss of accreditation for schools and the loss of teacher licensure for teachers if you violate this law. That one school district, we have in the record, the one school district said, quote, "We have no idea what this law means." So it's vague. It also, as I mentioned, infringes on academic freedom, particularly in the higher education context. The First Amendment sort of acknowledges that college campuses are special places where we want to encourage the broadest range of ideas to grow and flourish and be born. And so we look very harshly at any government effort to limit speech in higher education, and particularly with respect to scholarship itself. And this law reaches directly into the university classroom, and therefore is an unconstitutional, viewpoint-based, and overbroad restriction on academic freedom. Our third count is on behalf of students. So the First Amendment protects your right to speak, but it also protects your right to receive information. And students have the right to receive information. And several courts have recognized the concept that students have a First Amendment claim when state officials exclude information from the curriculum without any legitimate pedagogical interest, purely for partisan political gain. It's not, the First Amendment accords some degree of deference to officials to create their own curriculum, but you can't do it for nakedly partisan reasons that have no basis in any legitimate pedagogical interest. And the research, as Nico mentioned, is clear that far from being harmful, culturally responsive education, inclusive education increases students' understanding, it improves their behavior, and it even improves their academic performance. So there is far from any legitimate pedagogical interest to try to institute these bans. It has quite the opposite effect. So we're really proud to be a part of the first federal lawsuit challenging these laws, but I anticipate it will not be the last.
Thank you both so much for your presentation and remarks, and we welcome questions from our audience. And I'm going to start with perhaps just taking a step back for people perhaps who aren't as steeped in this work. Whether perhaps Emerson, I'll call on you first. Could you give us an example of either a current or a historical case where bringing a critical race theory lens could have helped with shaping better outcomes for communities of color?
Well, I want to hear what Nico's perspective on this, but it makes me, I'm a lawyer, so I'm going to obviously answer with a legal text, so I apologize in advance. But one of the things that the Oklahoma law bans is any concept that, quote, causes any sort of discomfort or any other form of mental anguish on behalf of students. And I think that this sort of gets to the heart of what Nico was talking about in terms of the benefit of CRT, in terms of giving people the vocabulary to describe what's going on around them when it's obvious and you feel it, but you don't necessarily, you feel some discomfort. When he was talking about in his San Jose school district, I've experienced as an African-American growing up in predominantly white schools as well. What these laws and bans do, they're so misguided, but I think that this kind of provision banning discomfort highlights what they're trying to say is, don't talk about racism or slavery because you'll make white students feel uncomfortable. It's aimed explicitly. We have quotes from these legislators that say we're trying to prevent from teaching about white guilt or white privilege. We want to stop that kind of teaching. So they're saying, don't cause discomfort by talking about race or sex. They're talking about their kids, white students. But it puts teachers in an impossible position, right? Because clearly what they're being told is don't talk about race or sex. But I know from my experience, what Nico's talking about is in his experience is that absence also causes discomfort. If you don't address race, if you don't address how different identities have contributed to our nation, to our world, then you're causing discomfort on behalf of marginalized people. So I know it's not a direct answer to your question, but I think it's clear that a culturally responsive education, inclusive education, can help students feel seen, feel a part of, and engage in classroom activities. And these bans on CRT are having exactly the opposite effect.
It's ironic because I think the fact that CRT actually says that, racism is normal, it's not an aberration, and you're not pointing a finger at like person A or B, should be cause to really think about, systemic change. But I think this is really part of a broader hysteria, for example, around certain novels that cause discomfort, or even the writings of the 1619 Project, Dr. Ibram Kendi. So I think this is just part of this historical amnesia that has been present since the founding of the country, which is recurrent around sort of rewriting the history of the country and ensuring that certain narratives prevail. So, Nico, I'll just turn it over to you to see what thoughts you have on this specific.
I think I would be remiss if I didn't repeat my CRT colleagues and Emerson as well, in saying that litigation and legal change is just one tool, and often an insufficient tool. But that being said, so just going back to the example that I said about different conceptions of what equal protection and anti-discrimination law should mean. So currently we have this model which is supposedly colorblind and supposedly only will delimit intentional acts of overt racial discrimination. You need to find a bad actor who you can show that one of the reasons that they chose to do this was because they wanted this racialized impact. And we're dealing with situations and the creation of racial inequality that oftentimes is now the product of market forces that are built upon prior racial discrimination. So one example from my litigation past is we were working in Modesto, California, with predominantly Black and Brown communities that were being denied municipal services because the city had never incorporated them. They were left outside of the city. Why were these pockets Black and Brown neighborhoods? Because of redlining practices, because of restrictive covenants that had locked in these communities to live in these particular areas which had been outside the city. As the city grew, they were just annexing other areas which made economic sense for them to annex. Didn't make sense for them to annex these areas which would have cost them more in providing sewers and sidewalks, police services, all these other things. But the continuing effect was real, which is to create health problems for these communities, public safety health problems for these communities, and the continuation of the inability to grow wealth in these communities because their houses weren't hooked up to services. So under the current the federal equal protection model, if we had to find someone who we could show that one of the reasons they chose not to annex these particular communities and give them the services, we'd have to show that it was the product of over discrimination. It was difficult to do that. The over discrimination occurred other times in the past. It was easy for them to offer us a neutral reason why. Now, one of the benefits was that in California, there are other anti-discrimination provisions under the California Constitution that don't require the same intent showing. And so there, we could see that we could bring viable legal claims on behalf of our clients to address the continuing racial subordination without having to rely on an intent-based anti-discrimination principle of equal protection that had been built up from the 1970s till now. And so the insights of critical race theory, which problematize these conceptions of law, which offer alternate conceptions of what equal protections could be then used to say, hey, maybe we shouldn't structure our legal claims in this way. Maybe we should have provisions of California law that go beyond what the federal requirements are. But in order to do that, it also requires the political project of people buying into the idea that racial discrimination isn't just the action of these individual bad actors. And to do that, that means giving not just ourselves as lawyers, because our vocabulary is constrained, because we have to talk to courts that only accept certain claims, but also to give other political actors, folks like Emerson's clients, the tools necessary to be able to talk about what's really happening to them and their communities and become their own advocates.
Can I just jump in quickly there?
Sure.
Quickly, Nico was talking about the real story has to be on behalf of the clients. I mentioned one of our clients, which is the Black Emergency Response Team. I would like to quickly mention, we also brought an equal protection claim, as Nico was talking about, alleging racial animus and a disparate impact based on race, according to this Oklahoma law. And we bring those on behalf of the NAACP of Oklahoma, the American Indian Movement of Indian Territory, and teachers and students in K-12 education, and the American Association of University Professors chapter at OU. But speaking to this, your direct question, Sushma, about sort of 1619 Project and the anti-racist authors of a variety of different varieties, the Oklahoma law doesn't mention specific text, but what we've seen in many states, like in Texas, they have, I think, a specific law targeting the 1619 Project, and they're currently doing library audits in districts across the state. So there, as you know, it's a recurring theme. As Nico said, we can't always bring a winning case in every single one of these situations. We don't have a plaintiff that has standing and a clear record or any of those things. But what's really clear is that the impact is already being felt in schools across the country, and students are being denied access to this information every day.
So one of the questions from our audience is the discrimination subordination distinction sounds a lot like the older intent impact distinction. If they're different, could you say more about how they're different?
I would say that we're often dealing with different terminologies for the same dynamic, and so sometimes we're trying to capture different conceptions. So one of the ways that I could say that like an anti-subordination conception of the equal protection might be different than just say the intent impact standard is in the context of, well, what if you want to try to use race in an affirmative way to address societal inequalities through, like, say, not just affirmative action, but through various districting policies to ensure integration. So an anti-subordination principle might not see an effort to remediate past discrimination or to address current inequalities or de facto segregation as being problematic just because it affirmatively uses race. And so in some ways, and this is just that an anti-subordination conception would also capture this additional part of it. But in large part, this intent effect differentiation is a large part of the anti-subordination versus anti-discrimination distinction that I mentioned.
There's a question for you, Emerson, specifically. How do you as a lawyer argue against this ban of discomfort? You were talking about discomfort earlier, and especially when we know that students of color feel and continue to feel discomfort.
Well, it's a good question, because sort of how, again, hitting on the theme, how you frame it before a judge the judge that we have in the Western District of Oklahoma was appointed by the previous president, President Trump, as many judges have been. So, but it's not just this court. In many courts across the country, the judiciary is not necessarily going to be a very hospitable place to arguments about critical race theory per se. So we have to figure out what are going to be our winning legal arguments before a variety of different potential judges. And so when we look at a provision like this discomfort, I mean, it's just wrong, right? Like you read it and you know what it's about, and you're like, that can't be right. But then getting from that to an argument that will, be based in case law that you think will potentially make good precedent is actually, the hardest part of my job, I would say. And I think for that particular provision, there's a vagueness argument saying we don't actually know it. It's too vague to say you're going to lose your license if you present any concept that makes a student uncomfortable. What does that mean? You can't ever make, of course, you shouldn't be trying to traumatize your students, but growth inherently includes some sort of discomfort. That's a part of the whole, you can't have a classroom discussion without some kind of discomfort, or you're probably doing it wrong. So I think, we'd have a vagueness claim, we'd have an overbreadth claim saying that it's going to cover it's going to ban all sorts of ideas that you don't have any legitimate reason to ban. And it also comes back to this standard, as I said before, of you have to have some sort of legitimate pedagogical interest that's being perpetuated by this restriction on speech. And a legitimate pedagogical interest is a pretty broad category, but this falls far short of any sort of legitimate pedagogical interest that you're trying to further. So we have a variety of arguments, but again, it's a weird framing to try to make it a successful legal claim.
One of the things, and this is just to add to what Emerson was saying, is that a lot of the bans on what can be taught are accompanied with other language about what needs to be taught. And oftentimes those pieces are about not talking bad about the founders, or arguing about the validity of kind of founding legal principles. Quite frankly, to big portions of the communities that I come from, whether they be Indigenous, Latino, or Black, a lot of not questioning those things, not bringing up the racism in our founding documents, not bringing up the fact that we were founded on elimination of Native communities can be traumatic. If you have to silence those things, that is a space where you feel discomfort. And I'll just go back to critical race theory. And Cheryl Harris and Devin Carbato, two professors at UCLA, wrote an article about the ways in which if you take out the ability to talk about certain subjects, which are particularly salient to folks from minority racial backgrounds, but you allow for this whole other discourse to continue without the kind of full background that allows people to present themselves fully, or allows the things that are salient to them because of their racial background, you are disadvantaging those particular groups. You are allowing for the discomfort of one group while claiming that the only discomfort that matters is for the majority group, which doesn't question the other concepts which are now being required to be taught. That's not to take away from that fundamental vagueness of what constitutes discomfort or when that discomfort can occur, but it does, I think, help highlight the ways in which the structuring of discomfort in these statutes really has disparate impact.
And Nico said better than I could. That is exactly our equal protection argument that's our fourth claim.
So, you've talked a bit about the struggle within the domain of education, right? Where these attacks on CRT, which are just not being taught in kindergarten, are part of this broader effort to deny learning about the country's history and history of enslavement, history of genocide, and sort of the long-term effects of those practices today. But that's also part of a broader dismantling of public education, really, that is taking place, and it's very intentional. And then parallel to that, in the public sphere, you see debates around issues such as removal of Confederate monuments and other kinds of issues in the public sphere that are being debated. So I'm wondering how much of the work is really legal work, how much of it is education, organizing, mobilizing, engagement work, or is it really a combination of both?
I mean, I will. This is my way of doing the good academic thing of like answering a different question that was asked. But I would note, I would note that the attacks that are happening on CRT, and I will let Emerson talk about this far more because this is one of the things that I think his project is really focused on, is happening at the same time that there are attacks on our ability to speak in other areas of the public sphere, be they in protests or in other areas. So, we know, and there have been reports by plenty of organizations on the attacks against immigrants' rights organizers, where immigration charges have been brought against folks who have been known to speak up and try to assert their rights in public fora. And we know that that's happening against activists in color in many other forums as well, at the same time that these attacks on critical race theory are happening.
Yeah, I mean, I would just say, I'm no education policy expert. I'm married to a teacher. I'm the child of two teachers, but I hesitate to weigh in on sort of the assault on teachers. But I will say that from the ACLU's perspective, part of the reason that I think I can be honest and say that we were caught a little bit on the back foot when these pieces of legislation were introduced, rushed through many state capitals, attached to budgets and other unrelated bills, in order to put in emergency sessions. The Oklahoma law was passed as a sort of an emergency measure that went into effect sooner than it normally would have. And at the same time, our affiliates in all 50 states have been fighting immigration bans. They've been fighting abortion bans. They've been fighting trans student rights. They've been fighting on all these different fronts throughout the country. So it is a part of, as I said, sort of this bigger picture, sort of cultural push and pull that we have. But it's been really hard for us to make sure that we can stay focused on all of these different things that are happening at the same time.
And like Emerson, I can't, or I'm not equipped to speak on kind of broader educational equity issues in terms of funding and the like. But I do know that even in the previous challenges to the predecessors to these type of laws, such as the attack on Mexican American studies in the state of Arizona, there the penalty would have been if you taught the banned concepts there, which involve the teaching of Mexican American history, including the political struggles for equality of the Mexican community. One of the penalties was a defunding of the school in part, and the teachers there were really frightened that where they were already on the limit of their ability to maintain their jobs and do their jobs, that funding cuts like that would really impact their ability to be able to continue to provide the kind of education that they wanted to students. And it just spoke in many ways to the vulnerability, the economic vulnerability that our schools are facing, and that, quite frankly, our teachers are facing in many parts of the country as well. So I think that's your question invites a symposium to address, and I hope to attend that symposium one day.
So there's two questions from the audience, and I'm going to kind of merge them into one question. So how does CRT incorporate the issues that affect various communities of color outside of African Americans? And will CRT be a step towards introspection, not only about racism, but also other challenges such as, gender discrimination and so on? Intersectionality.
Well, yeah, I mean, one of the things that's impossible to do in 15 minutes is to describe the various contributions that critical race theory has made to some of these discussions. I think one of the foundational insights of critical race theory is this notion of intersectionality, which really we can really credit to Billy Crenshaw, who was, in many ways coined the term and was really one of the founders of critical race theory, who really explained that you can't just explain, for example, a Latina woman's issue just by saying, oh, all Latinos face discrimination or all women face discrimination. You really have to understand that these things combine in various ways. And then unless you understand the particular forms of discrimination that this group is facing, you won't be able to address it. And you can't just do it by looking at one of their identity categories or another. We have other folks that are spinning this out even more. So, for example, there's a scholar, Priscilla Ochen, who's done great work and who has been part of the Carr Center talks before, who's talked about, well, how are Black young women in specific affected through these multiple lenses of their race, their gender, and their age, and how are they delimited from making certain claims as to, whether or not they should be treated as youth rather than as adults, or whether they're held to, greater, whether they're subject to greater penalties as a result of these intersecting forms of subordination. And so I would encourage folks to go back. I think that talk might be recorded, and hear how some of the critical race theory lenses get used to talk about those intersecting forms of subordination.
And I can just add that many of these inclusive education bans, including the Oklahoma one, the text that I showed you, it talked about race or sex. In every instance, it talks about discrimination or stereotypes based on race and sex. And I think in that way, we have an obvious gender component, but one provision that I didn't show, which is also directly targeted at this particular issue, is that they banned, I have to read it every time because it's so confusing, but gender or sexual diversity training or counseling. You can't have any mandatory gender or sexual diversity training or counseling. So it's we know that racism is central to this effort, but it is not limited to race, and it is not limited to one part of people's identities. And sort of the breadth of all that's being sort of thrown under CRT is both a credit to CRT's work in terms of opening the door to other forms of inquiry, but I think it's also sort of this use and co-optation of the term to mean anything that's inclusive in any way. And I would just say, thanks in large part to my colleagues in the Women's Rights Project and in the LGBT Project, when you talk about sexual stereotypes, that includes sexual orientation, because the courts have found that if you discriminate against somebody for not fitting particular gender roles, norms, or fitting some stereotypes, whether that's you're too masculine for a woman or too effeminate for a man, or some combination of the two, that is discrimination based on sex. So we are definitely seeing, and I've been in touch with our colleagues in the Women's Rights Project and in the LGBT Rights Project, because it's true, their constituencies are worried about these laws as much as our BIPOC students are as well.
So another question from our audience is around how does CRT address conflict or hierarchies within communities of color, such as the LA race riots, they say?
I think there's been a large body of, I'm not familiar with the scholarship on the CRT scholarship on the LA race riots, so I can't speak to that in specific. I'm sure that there's been some writing on it, but I know there's been extensive writing on the ways in which often there's moves towards anti-Blackness for other communities of color as a way to try to ameliorate the subordination that they're facing. You see this often in on immigration cases where some minority community, some racial minority has said, well, I should be allowed to immigrate. And this is coming at a time when there were formal restrictions on immigration based on race. I should be allowed to immigrate here because I'm actually white. I might be South Asian, but really I'm not like the people of color that you want to ban. I'm really more like white people, or I'm Japanese. We're very culturally, we share lots of cultural similarities with whiteness. Please don't subject me to racialized bans. And so you see moves towards whiteness on one end, and there's been a lot of discussion about how that occurs. But other times, there's been times where groups have tried to contest their inclusion in segregated schools, where groups have said, we're not Black, so you shouldn't send us to the segregated school. We're in fact more like the white students, and that's a real incentive for marginalized communities to try to grasp for. When you're facing oppression, to say, well, I need to try to move towards a mechanism to minimize it. And in the United States, one of the ways in which social status can be achieved is by moving towards whiteness and away from Blackness. And there's been several scholars who have talked about this in the context of various communities. I know, for example, Laura Gomez has talked about moves towards whiteness and away from Blackness within Latino communities, as have several others. And so it's one of the things that we have to keep in mind when we're attempting to build cross-racial solidarity, is this kind of racial bribe that can happen. And part of naming the mechanisms of racial subordination is it allows us to both confront and address those things, much in the same way that that confronting and naming sexism allows us to build to fully incorporate women and men into the same social movements while contesting forms of sexism. So I think that critical race theory actually does a good deal of work in attempting to both once again build the understanding, the vocabulary, and the forms of praxis to allow us to address some of those racial tensions and build towards an anti-subordination movement.
Terrific. Emerson, any closing thoughts?
I'll just say it's a pleasure to work in such a strong coalition. I mean, the number of folks who came out for this webinar is indication of the broad range of folks who are trying to engage. I can't tell you the number of emails I've received from every type of organization, every type of profession, every industry who's saying, look, this is affecting us in some way, or we're worried that we're going to be next. And so I appreciate the solidarity. Sometimes we sort of get so caught up in our filing deadlines and in making sure that our briefs are perfectly proofread, which is what I'm about to go do now, is proofread a brief. But it's good to connect with the wider world in some sense. And I definitely appreciate everybody on the call.
Terrific. So we do have some resources. Nico had referenced our webinar with Priscilla Ochin, which was from earlier in the fall on the Carr Center YouTube page. It's on intersectionality. And I'd also recommend the African American Policy Forum and UCLA Law School, where Kimberly Crenshaw is based, where there's a lot of amazing articles, webinars, videos, podcasts, to really learn more about this topic. So thank you all for joining us today. And thank you, Nico and Emerson, for your time and your ideas.